171 Friday group meeting. The topic is appointment of judges. The speaker is Mr. Vikas Singh, senior advocate and president of our SCBA, Supreme Court Bar Association, one of the topmost senior advocate of this country and very staunch supporter of our bar. Sir, few introduction we will give him, even though you know. 171 sir, yours is going to be, and 122 videos are available. We have our own channel in YouTube. 122 videos already. It is going to be yours is 123, and 24,500 subscribers we have as on date. And plus 10,72,524 viewers we have all over globe. That's a great achievement.
So you crossed 1 million.
1 million we celebrated also. That is the one. And we started this Friday group 2015 July 10th. Here is the safe table. So that is one. In pandemic we are not continued. The reason is naturally this court was closed. But we benefited, Friday group YouTube channel benefited. We have 5 lakhs viewer in that period. Otherwise 1,42,000 only, and at the end of that we have benefited 5 lakhs viewers. Justice Indu Malhotra, Justice Udayu Lalit, Justice Narsimha, Justice Nagratna ji, and Rama Subramaniam, 5 judges as on date they addressed here. That is a proud moment for all of us. So in addition to several advocates, so Kavya will say a few words about CV. Kavya? Yeah, please.
I have to hold it like this. A very good afternoon, everyone. Today we have amongst us as speaker Mr. Vikas Singh, who is an eminent senior advocate practicing in the Honorable Supreme Court of India with standing of over 32 years at the bar. He has been the Additional Solicitor General of India from 2005 to 2008. His contribution, as we all know, in the field of law and public life is immense. Mr. Singh, while appearing as a law officer of the Government of India, has successfully represented the government in diverse matters ranging from income tax, central excise, customs, COFEPOSA, narcotics, company matters, preventive detention, etc. In all these matters, Mr. Singh has got important law laid down by the Honorable Supreme Court while defending the interests of the Government of India. And some of his judgments are also reportable and available in journals as well as the materials which are used by students in preparing for law. Mr. Singh, in his address in the Indian Parliament to international delegates immediately after 9/11 incident, suggested that a law should be enacted to prohibit the media from any terrorist organization from publishing any photograph of the terrorist, so as an act to disincentivize the terrorist organizations, since invariably terrorist attackers take pride in this moment. So he demanded that a law should be made curbing the same and prohibiting the media. Mr. Singh has authored various articles on the blemishes in the collegium system and appointment of the judges, which has been widely published and has even received support and applauds from the sitting Supreme Court judges, apart from the local public. Mr. Singh has represented eminent personalities from the business and the political world, and he is perhaps the only lawyer associated with the causes of 3 temple cases in India: Ayodhya Ram Mandir, Guru Ravidas Temple, and Bal Yogi Shri Sadanand Maharaj Ashram. And the irony is he has won all of them. So that is a matter of great pride. Keeping a special knowledge in the field of law, Mr. Singh, apart from having special knowledge in the field of law, is the chief patron at the Delhi Foundation of Deaf Women, and he is committed to the cause of handicapped and disabled children. He has been promoting education of the girl child with the philosophy that educating a man is educating a person, whereas educating a girl is educating a family. So this is a thought which everyone in the society should perhaps adopt. Mr. Vikas is currently the president of the Supreme Court Bar Association, the post he is contesting and fiercely holding since last three terms. While holding the post, he has taken various interests and done a lot of things for the people at the bar, including the infrastructure of the bar. So today he'll be delivering a lecture on the topic of appointment of judges. And Mr. Vikas Singh sir, we are all ears to hear you. It is an honor to have you here. Thank you, sir.
Claps. Please start.
So Appointment of judges today is a very, very live subject, and it is being debated everywhere, including on the streets and in drawing rooms. Apart from, of course, the government and the Supreme Court being at loggerheads, and this tussle is an ongoing tussle, probably not desirable the way it is unfolding, but nevertheless it is on, and so it's a subject which I thought is a good subject to talk in this August forum and to discuss what are my views on this subject. So the collegium system was brought in by the second judge's case, so to say. S.P. Gupta was the first judge's case where they held that the executive has the primacy to appoint and transfer judges, and the second judge's case was the case which by 9 judges held that no, there should be a system by which the judges should appoint the judges. And the philosophy of delivering that judgment was that when the Constitution talks of consultation, because in the Government of India Act there was no consultation. The judges were being appointed by the government themselves, and there was no requirement of any consultation. But when the Constitution was drafted, they put in the word of appointment to be made with consultation with the Chief Justice of India. So while interpreting the word consultation, the Supreme Court opined that consultation will mean giving primacy to the views of the Chief Justice of India. And unless they say that primacy is there, then that consultation is meaningless, because they also deliberated on the basic structure doctrine, and they said that independence of judiciary is part of the basic structure of the Constitution, and by ensuring that the best are appointed, we are also in a way ensuring that the basic structure is maintained of the Constitution. And on these two arguments, basically they said that since the primacy has to be there with the Chief Justice of India and his view has to be final, and if there is a view of the government which disagrees with his view, they have a right to send it back to the Chief Justice of India, and once he reiterates it, then that view will be the final view, and literally the notification has to happen once the reiteration takes place. In the original judgment, it said Chief Justice with 2 judges, but then it was sent back to reference again, and immediately thereafter, a couple of months thereafter, again 9 judges sat, and they interpreted that for appointment to Supreme Court it will be 5 judges, for transfer it will be 5 judges, and appointment to the High Court it will be 3 judges. So this system was put in place, and accordingly since then the Constitution has been read to mean that the names will start by a recommendation by the High Court, it will go to the government of the state, then it will come to the Chief Justice of India, and Chief Justice of India will, in consultation with 2 judges as far as High Court appointment is concerned, and with 4 more judges if Supreme Court appointment is concerned, will make their recommendation, and that recommendation ultimately is the final say. And government thereafter has only a ministerial function of issuing the notification, unless the government has a view to return back the names for some good reason, and then upon reiteration by the same collegium, that view will be binding on the government. So that is how the system has been going on since the second judge's sort of case, because S.P. Gupta is considered as the first judge's case, and this collegium is considered to be the second judge's case. Then came the NJSC. So the government felt that this system was not working properly, and they felt that we should have a say in the appointment of judges. So they promulgated the NLJC, the NJSC, they amended the Constitution and provided for a National Judicial Academy for appointment of judges, which is NJAC, and they said that there will be a committee of some eminent people and the government and the judges which will finally decide. And there was a second limb of the NJSC which unfortunately is not debated much. I rather has never been debated much. is the element of shortlisting names. So there were two elements of NJSC. One was shortlisting the names, and the second was who will appoint the names. So when this challenge happened in Supreme Court, the challenge was only on the second aspect of the matter, that the primacy which has already been determined by the 9 judges, that should not be taken away, and the moment the government has a bigger say in the appointment process, and if the veto, so to say, shifts to the government, then in a way it is diluting the first judgment of the, or rather second judgment, the main collegium judgment of the Supreme Court. And accordingly, the NJSC by 5 judges ruled that this amendment is bad, and the constitution will revert to the earlier system, which was the collegium system, which was brought in 1998. And in this judgment, there was no discussion at all with regard to the criteria for selecting candidates, and there could not have been any fault with that, because that was not the basis for challenging the NJSC and that judgment. Now, with the NJSC judgment, there was a memorandum of procedure which was envisaged, and there was a memorandum of procedure again where the judgment said that the memorandum of procedure has to be formulated by the government, but it will come into effect only if it is unanimously approved by all the 5 judges in the collegium. So that is where the catch is, that the memorandum of procedure, which the government has been insisting till today, is being delayed or is not being formulated, is awaiting the 5 judges approval, and since that has not happened, so whatever memorandum of procedure that they were following from before, they are insisting on the same, and that is probably one of the grounds, a very important grounds for the tussle happening between the judiciary and the government of appointing judges to the higher judiciary. Now, when the government lost the NJSC, the government, according to me, I had a talk even with the then Law Minister, Mr. Ravi Shankar Prasad, and I said that the fact that you lost the NJSC doesn't mean that all is lost for you. You still have the power to bring in a law where you give the primacy to them, but at least get yourself involved in the selection process. But somehow he didn't take that idea of mine with so much of interest. Then I drafted a legislation also on this. And the draft read, the bill that I drafted was that a bill to regulate the collegium system. Because, and I'll come to the experience that we have had thereafter, which of course is not very happy. But the idea was that basically, whether it be the collegium or the government, the interest should be that good people get appointed. Interest should not be that who will appoint. I mean, in that fight for taking control over the appointment, somehow the real issue of getting the best people appointed is being lost. So collegium says we have the right to appoint, government says we have the right to appoint, but whether it be the collegium, as experience will show, and I'll discuss on that a little later, whether it be the collegium, whether it be the government, the larger intent doesn't primarily appear to be to get the best people. The larger intent appears to be to keep the control. And in keeping that control, according to me, in these years, now we are about 25 years of the collegium system, and in this business of keeping the control, so this and I'll explain what, according to me, is the why this is such a big casualty. If you go historically, prior to the collegium system also, judges played a very important role in designated seniors. Designated senior has always been part of the judiciary. That has got nothing to do with the government. So you designate people who are good in the profession and who are are doing well and who have that integrity. So you designate seniors. So when you say that you are going to designate seniors, the idea is that you want to look at the future of how the profession will be, how a professional who is doing well in the profession should be groomed to take on, the mantles of today's, the, so to say, the legal, luminaries of the today. So every legal luminary today will not be there tomorrow. I mean, that's a proven fact. Nobody is here, nobody is immortal. So we have lost some, greats of our profession recently. We've lost Mr. Ashok Desai, we lost Mr. Soli Sorabji. We've lost so many of them in the recent past. So you have to fill that vacuum also, and somebody has to be groomed for that purpose. So judges have been doing this responsibility of appointing senior advocates. This is a job which is with them, and this is something which never been questioned. Nobody has even tried to take over this function from the judges, and this function remains with them. Nevertheless, that power is with them. When they think of elevating people to the judiciary, invariably the problem which I perceive is happening is that the judges who are genuinely looking for the right people also, who want good people to be appointed, invariably end up requesting people who are actually wanting to make a future as a senior advocate, who are not the right material to be elevated as judges. Because if you look at the profession, you need good judges, you need good advocates also. This profession will be suffering a huge loss if our good senior advocate materials are made judges, and there is not enough talent left behind to, assist the court in matters. So even where they are actually looking at good people, they say the basis for the second judge's case and the third judge's case is that we know the lawyers. And since we know the lawyers, we are in the best position to decide who will be good for elevation. The real category is the lawyer who is doing the drafting. The real category is the lawyer who is strategizing, who is briefing the senior. The real category is the face which is not visible in courtrooms. Because if you actually try to identify them, they will make the best of those judges, and a person who has the potential of becoming a good senior advocate probably is not. So when they say that we ask people to get elevated, most of the lawyers refuse. The ones they refuse are the ones who are, aspiring to become senior advocates. So if they are not accepting, the reason is that you are targeting the wrong group. And I say this, and I'll just give one small example that I started my career with Mr. L.R. Singh, and I say this everywhere, that he was a very fit material for being a judge. But he will not ask anybody, he will not go to anybody, he will not, he will not show his inclination to become a judge. And according to me, these are the best qualities to become a judge. And I'm sure there are hundreds of similar lawyers in this court who, if they are properly asked, requested in a dignified way, and told that please you have to give back to the system also, they will take this elevation. But otherwise they are doing so well monetarily. A lawyer, an average lawyer, the earning of an average lawyer is far, far in excess of what a judge's salary will be. So for expecting any good lawyer, whether it be only drafting also, to take over judgeship is actually asking him to do a sacrifice. And this subject has been a very sore subject as far as this bar is concerned, and I have taken this up right from my first stint as president of the bar, that Supreme Court lawyers are not being considered at all in this whole gamut. Except, again there is a caveat, except one or two lawyers who, because they were juniors of a particular Supreme Court judge who gets into the collegium, pushes their name, they make it. So those are again the wrong way of making it. Why should only a person who has worked with a Supreme Court, with a person who finally makes it to the Supreme Court and who ends up in the collegium, why only because of that proximity that you should be made a judge? Why should there be not a system in place where somebody should be looking for the right people in the profession, whether it be in Supreme Court, whether it be in law firms? I say even in law firms there are some brilliant minds, and they will be very good judges if they were again they are called. Law firms also, mind you, pays very well to their lawyers. So whether it be any lawyer working either in a law firm or in practice who's worth the salt, who deserves to be elevated by virtue of his integrity, his intellect and his standing at the bar, will be a loser as far as financial is concerned. So to get the right people, you have to make a request to the right, to firstly identifying in a transparent manner to see that the right person is selected and then requesting him. I remember when Justice Dalwin Bhandari was the Chief Justice of the Bombay High Court, he himself narrated this incident to me, and there are several Chief Justices who have done that effort of finding the right people, and the Justice Dalwin Bhandari comes to my mind. Even Justice Sanjay Kaul in the Madras High Court did that exercise. I know several High Court Chief Justices who have really taken that effort to find out the right names and got them elevated. So Justice Bhandari told me that I identified some 7-8 names and called them, all of them refused. So I said, I'll come to your homes and you have your parents with you, have your wife with you. I want to meet all of them. And he said, out of those 7, I could convince 3, and they ultimately took the judgeship. But again, in that exercise, probably he may have identified those people who would be appearing before him, whom he finds to be good in argument, who are more, I would say, their argumentative skills are good, and they are, in a way, you are doing harm to the system by only identifying those people. I'm not saying that those people should not be elevated. If they are interested, they should definitely also be elevated. But when you think of the profession as a whole, and when you, as a Chief Justice, look at taking the profession to a better level or to improve the system in the profession, then you have to carry. So according to me, these are aberrations in the system where the right people are not being selected, and with the result that the system is losing. Now, when we talk of a democracy, what is a vibrant or a throbbing democracy? Which democracy can be said to be a proper functional democracy, so to say? For any democracy to be proper, functional, and vibrant, the two important limbs in that democracy are that, or rather 3 important limbs are that there should be civil liberties, protection of civil liberties, there should be a free press, and there should be a free judiciary. If and all the other 2 are irrelevant if they. Now, when you select judges, I feel that one of the very important criteria is that a judge should be decisive. And most of our judicial delays happen at all levels is because judge is not able to decide. Now, you may be a brilliant mind, but the brilliant mind, if he is not decisive, doesn't take you. You may just keep on debating on a particular issue, but not being able to decide is a very important quality which should be looked at before elevating somebody as a judge. And according to me, there is no thought in that process. You may, if a judge is not able to finish his board in the day, according to me, he is not decisive. He is not able to. There is a huge amount of time management which judges have to do, and this court has always had this system that whatever matters are there on a miscellaneous day, because people come from all over the country to this court to get their matters, and most of the time clients come, and lawyers also sometimes come from outside. And if a matter is listed on a miscellaneous day and not, I can understand a regular hearing doesn't reach, and that is justified. So because on a regular hearing day, some matters may not reach because one matter was heard for a longer period of time. But on a miscellaneous day, if matters are not getting over in a particular bench, then that bench is not decisive, and they are not able to take a call. They are not able to manage time properly, and they are definitely, I would say, not good judge materials as far as that decisive angle is concerned. Because if a person, and I've seen this in high courts also, lawyers are repeating the same argument again and again, and the judge is hearing them. If you have heard one argument and if you feel that that argument doesn't impress you, don't please allow him to argue it again, or a second counsel to repeat the same argument again. So these are qualities which a decisive person will, and we have all seen judges in this court, we have seen judges who will not allow you to make across should be understood by the judge. If after understanding he feels something against and he still decides against that, nobody has any control and no lawyer will have any grievance to that. But if the judge either is not giving enough time or not ready to hear you, that is also not correct. Letting you argue the same thing 10 times again is not correct. So both kinds of judges we have who either don't hear you at all or who keep on letting you argue or same thing again and again. These are qualities which according to me is definitely a quality which should be looked into at the time of elevating somebody to the higher courts. The other problem which I feel is lacking in our system is that apart from the system of who will appoint and how people will be appointed, justice delivery has become very, very, I would say, in many jurisdictions, very technical. And this, even the present Chief Justice of India has said in a public platform that when we were in the high courts or even as lawyers, we have not dealt with a particular subject at all, and we are expected to deal with that subject, that at the Supreme Court level, and hear that subject for the first time. And it is quite a lot of strain for us to understand that particular jurisprudence. For instance, intellectual property, or even somebody who's not done criminal law for the first time, or any jurisdiction which you have tax law. These are very technical. Environment law is slowly becoming very technical. So in this there are two aspects. One is that when you appoint judges to the high court, especially the high court, there is no data being prepared of the matters of a particular jurisdiction that are pending in the High Court. So for instance, there is no data that if there are 1 lakh cases pending, how many are criminal matters, how many are criminal appeals, how many are bails, how many are tax matters, how many are service matters, how many involve the constitution, interpretation of the constitution, how many company matters. If that data is there, then probably you can also decide that in which jurisdiction how many judges you want. So if you have, say, out of 1 lakh cases, supposing 50,000 cases as criminal matters, then obviously you require more judges who know criminal law. You just don't appoint because somebody is in front of you and he may be doing a good argument. You have to appoint also looking at the various pendency and or rather the litigation history of that court. Pendency also, really speaking, is not important because pendency in some jurisdiction may go up because you didn't have judges of that jurisdiction, and pendency in that has gone up. So litigation history will give you a better picture where you will know that so many criminal appeals are filed in a year, or so many tax cases are filed in a year, so many service matters come in a year. So if you go by a pendency come the judicial history of the court, then probably you can decide that what kind of judges of what discipline you require for that particular high court. And it is not necessary that somebody who has not done criminal law may not be able to do civil or vice versa. If a judge is good in good first principles, normally he is able to adapt to the other also. But that happens more in the Supreme Court. Because Supreme Court, it's very difficult to control from which branch of law you are for the purpose of getting elevated to the Supreme Court. So Supreme Court, you are in any case, you have to deal with every jurisdiction in the formations that Supreme Court has and the way the Supreme Court functions over a period of time. So especially at the High Court level, this definitely should happen, to see that in which jurisdiction we require more number of people so that elevation happens, taking that into consideration. Now when I say proper, there should be, when I drafted this law on collegium system, so the the thought which I had in mind and which I have given it to the law minister also, and he also mentioned my name in parliament, and he said the president of the bar has given him a law. I don't know what he's doing about it, but I don't think he's done anything about it as yet. But when I say that you should have a system in place for at least shortlisting names in a transparent manner, so I suggested that if you decide, the collegium decides, so collegium will have the final say. If they decide that they want people from the age of 45 to 50, fortunately with the advent of technology and the information technology, you know, percolating everywhere, if you want to know people from that high court who are in that age group of 45 to 50, if you put everything on the if it is online available, and most of the high courts have this kind of information available online, bar councils have information available online, and if you don't have it, then have some data processors to put it everything online, then you can get the names of people who are in that age group. So then the collegium says that we want income of a particular, every high court will have different, so some high court may have 10 lakhs, some high court may have 20 lakhs, depending upon what is the average income in a particular high court. So you say the income above this, so that could be again online, that could be found out. Then you say how many reported judgments, at least 5 reported judgments. Again online, you can find out how many reported judgments a lawyer has. And then once you are able to get that database, then somebody applies his mind to all of them and probably talks to each one of them and to find out whether they are inclined to become judges or not. And then I have suggested that there should be, in every high court there are 2-3 definitely eminent lawyers who can be consultees in the search process, not in this final appointment process. In the search process, so you have eminent lawyers in every high court. You can find out an integrity of a lawyer. Nobody knows better than the bar itself. The bar is everybody knows if a lawyer is having a doubtful integrity, then bar everybody knows. Judges may not know, but bar definitely is knowledgeable of that. So you are able to do that. So once you do this shortlisting, you are able to get that integrity check, and then those names should go to the collegium. So the purpose is that the collegium per force is compelled to apply its mind to all the eligible names who are fit to be considered as elevation as judges. Now, what is happening today, and I don't blame the present system in one way, I mean, where the judges are actually wanting to get good people elevated, I don't blame them in one way, because the senior most judges invariably are the most busy judicially also. The senior most judges, and especially the Chief Justice and the JD1 as they say in the High Court, which is the number 2 and the number 3, have lots of administrative work other than selecting names for the, other than participating in a collegium meeting for elevation of lawyers. They have to do administrative work with regard to the maintenance of the High Court building, administrative work with regard to senior designation, administrative work with regard to promotions of the High Court employees. Then a judge, a senior judge invariably has to carry his files at home, he has to read briefs at home, he has to write judgments at home. And people don't realize, they say judges take holidays. I remember once Justice B.R. Gopal sat in the Delhi High Court and 3 days he dictated a judgment. So 3 days he didn't take any matter. He just kept on dictating a judgment. If a judge starts dictating in court the big judgments that he delivers, then you can just imagine the kind of time will be wasted of the other matters not being taken up for hearing. So with all this kind of work, where do they have the time to try and find out who are good people to be made judges? Where do they have the time to devote that kind of energy and that kind of initiative they have to find out that this person is a good draftsman, he drafts very well, or he is the one, the senior who whatever he is arguing is actually prepared by him. Invariably this court has seen that very many seniors depend totally on the briefing by the juniors. Now the real brain is of the junior who has actually told senior what to argue in many cases. So That junior is not visible. He's sitting next to the senior, and his name probably is not even written in the report as of any consequence. So the real merit who should be considered for elevation is not being looked at by anybody. The system does not have a inbuilt mechanism to pick up the right people who will be having the right integrity and the right legal knowledge and to be elevated as judges. So that exercise is not happening at all, and unfortunately this part nobody is talking about. The entire discussion that you will see in the media and everywhere is that who should appoint, that whether judges should appoint or whether the government should appoint. I say whoever appoints, first do this basic exercise of who should be appointed. And my grievance with this present collegium system is that nobody is thinking of this, that who should be appointed, who is the right candidate. And what happens in the process is that, you know, a lawyer who's doing well otherwise in life, and if he's not called at the right age, if you ask him why, when he becomes 52, he'll say, yaar, aapne 45-46 mein to pucha nahi. They all get the advantage of getting elevated at 39 and 40, but now they say, no, below 45 will not consider. Why should you not consider if there is somebody brilliant to be elevated even below 45? But that exercise has to be done somebody to find out who's the right person to be a judge. That exercise is not happening. This is according to me, today, in fact, we've been in talk on this for this meeting. I've not been able to give time. Somehow I've had matters in the afternoon. Today also when I had agreed, but today also I had a little bit of, I'm on a very heavy antibiotic, but this is such a close subject to my heart. I said, no, even on antibiotics, I must come and speak on this subject, and you know, because this voice has to grow. This voice that the right people have to be identified everywhere, and the right people, when I say right people, means again looking at the larger picture. The ones who are fit to be senior advocates are not the right people to be elevated as judges. Of course, I was only asked casually, but even if somebody had asked me very seriously, I would have refused to become a judge. Not because I don't want, it's the money part, but because of my intrinsic nature of wanting to be, you know, generally with people and helping people in whatever which way I can. As a judge, you can't do that. So there are people who don't want to become judges for that reason. But at the same time, if there is nobody trying to find out the right people, then somewhere down the line, this process will degenerate further, and we will be, you know, we are going down the drain already because the way judges are being. So this, according to me, is one of the very big issues in the collegium system, and there is a requirement for a larger debate on this subject. And I am very happy that I was invited for this debate today, and I thought I'll share my views with all of you. Thank you.
Great lecture.
Thank you very much, sir. Very nicely you explained. You are the helm of the FOC, you know good and bad. You have vast 32 years experience. But our Friday group is only an academic group of Supreme Court advocates, a continuous education, legal education initiative. Members will decide what exactly they want. So these are all crystal clear in front of us. I mean, both the sides. Earlier we have executive system before this collegium. Now after collegium, several this thing. I think maybe relook may be required. Looks like the way you are the best judge. Thank you very much. Let us give a standing ovation to sir. So.
Thank you.
We'll take your autograph, sir. Give your autograph. Join for a cup of tea in the canteen, please. Message will take next, please. Very good attendance, sir. In our attendance register, please, Kavya.
So, Mr. Singh writes, it has been a privilege for me to speak to this August Friday group. I spoke on a subject close to my heart, and through this talk, I would want a larger debate to start on this very important subject.